This video is the fourth in a series related to design risk and building control regulations and is based on the CIF's practice note on this subject published in 2022 and available on the Contractors Resource Hub on the CIF members website. This video will actually attempt to outline what are the appropriate ancillary certificates under the respective contract or subcontract arrangements that should be provided by a contractor or an assigned builder regarding design in particular. The contractor or assigned builder should be extremely vigilant in this particular space when assessing requirements to provide ancillary certificates. A lot of that is going to be related to perhaps who's seeking the certificates, what they're seeking them for, and what the contractual makeup is. And I know that's been covered in a number of the previous videos. In the absence of a clear contractual obligation to do so, the certificate perhaps should not be provided, and that's where it might be quite prudent for a contractor or an assigned builder to actually ask a question and seek professional advice. If it's to be provided under the contract, care must be taken to make sure that it is a standard in the standard format, in the appropriate format, and reflects what's set out in the statutory requirements under the Act. You need to be very careful where you're being asked to sign bespoke forms of ancillary certificates that perhaps are driven by other parties to the project wanting to eliminate or pass their risk down the supply chain. The Code of Practice for Building Control Amendment Regulations, or BCAR, published by the Department of Housing, Local Government and Heritage, notes that there are 4 certificates required to be submitted under the building control regulations. The first one, the design certificate, is signed by the design certifier and provided at commencement stage. The second one, the form of undertaking, signed by the assigned certifier at commencement stage. The form of undertaking, signed by the builder at commencement stage. And the certificate of compliance and completion, signed by the builder and the assigned certifier at completion stage. In addition, the Code of Practice notes that there will likely be a range of other ancillary certifiers on most projects, and that's what we want to focus on here in this video primarily. The CIF would advise members to seek professional advice before deviating away from any of the standard forms of certification, and when they're trying to consider what type of ancillary certificate they should provide. The building regulations do not in themselves specify ancillary certificates which must be provided to the design certifier and the assigned certifier. They only require that the design certifier provides the design certificate to accompany the commencement notice, and the assigned certifier provides the certificate of compliance on completion, both of which expressly rely upon ancillary certificates which are scheduled thereto in those documents. Under the Code of Practice, the Building Control Amendment Regulations Code of Practice for Inspecting and Certifying Buildings, Section 3.5c and 3.5e, the words are specifically set out in conjunction with, can be translated as in unison with, jointly or together, leaves the duty or right of determining the parties required to provide certification to the assigned certifier in conjunction with the assigned builder. That's a really, really important statement, because what that demands is cooperation and agreement between those two parties to set out what ancillary certificates are required and certainly required to be part of the statutory certification process. The requirement for a meeting between the assigned certifier and the builder prior to commencement is explicit. It's also implied in the Code of Practice. It's explicit in the formation of the inspection notification framework. The 3 parties involved there, the owner, the builder and the assigned certifier to that document. And it's then implied in the Code of Practice as referenced above in Section 3.5, subsections C and E. The BCAR process is separate from a contract. And that's something that's been relayed in the previous videos as well. It's very, very important to differentiate. You can agree under contract to do anything. The BCAR process is quite separate from the contract, and that's been established already in our previous videos. What's really, really important is you can agree to anything related to certification in contract. What we're talking about here is what the statutory process demands, and then what the statutory process talks about in support of that in terms of identifying ancillary certificates that would be good or would be prudent to provide. And again, what we're pointing out is that is by agreement, by coordination between the assigned certifier and the assigned builder. The builder must be given an opportunity to review the supporting documentation, this supporting documentation list, prior to lodgement of the commencement notice. This includes the design certificate, the schedule of associated ancillary certificates, and the list of items that are remaining to be designed. It obviously gives the builder, the assigned builder, an opportunity to really consider what risk remains on the project, and also perhaps how that design might be developed and how they need to monitor the design as it's developed. It also informs them and gives them a position of educated understanding as to how well detailed the building is. In the event that building control wants to engage, they'd be able to explain to them, well, these particular elements or these parts of the building are actually designed. These particular elements or systems or parts of the building remain to be designed. So it gives them a chance to prompt the design team and seek more detail where building control might actually have that query. The builder should accept the assignment, have the meeting with the assigned certifier, review all of the above documentation that we've just set out, and only then upload their undertaking, this statutory certificate, the undertaken by the builder, to what's called the Building Control Management System, the BCMS. Liability for incomplete, unassigned design should remain with the employer unless it's clearly designated and allocated to someone else in the project team. The industry practice notes and agreed forms of ancillary certificates have been established as a result of discussions between the different industry stakeholder partners, the RAI, the CIF, the ACEI, Engineers Ireland and SCSI. They've been developed and there are standard forms that should not be amended and should be used for very specific circumstances. The very specific circumstances depend on what you've been appointed to do contractually, and that's where the contract, as outlined in the previous videos, is very, very important as the foundation for what you must do on the project, as opposed to what statute demands and what must be provided under statutory form of certification. They also set out not just what the assigned builder is going to provide, but also what subcontractors, specialist subcontractors and sub-subcontractors or sub-suppliers and specialists are going to actually provide as well. Separate forms are actually specified for certificates to be submitted at design stage and for the purpose of the commencement notice, and then also at completion stage for the purposes of providing satisfactory documentation to show that the project has been completed in line with what was originally envisaged, designed, and what people said at commencement stage they were going to do. The design certificate and commencement notice themselves are very important documents. The BCAR are very specific regarding what should be contained in the commencement notice itself, regarding the design certificate, elements that have been designed and those that remain to be designed. And that's a very, very important distinction. It's very important that contractors are aware how far has design progressed, what's completed, what is going to be completed by the design team, who's responsible for completing that design, because it allows them obviously the opportunity to engage and seek confirmation on a phased basis. When will we actually receive that information? Because it allows them to actually begin to consider their procurement process, their allocation of subcontract packages, and then also the consideration of what ancillary certification might be required to complete those works. In respect of the design certificate, section 4.3 of the Code of Practice states that the design certifier signs the design certificate that is lodged with the commencement notice and ensures that any necessary ancillary certificates from members of the design team are scheduled and lodged as necessary and appropriate. Article 9 of the Building Control Amendment Regulations sets out that the certificate and notices which must be provided within the commencement notice. The most significant accompanying document to the commencement notice is the design certificate. A particularly important provision in the Code of Practice is that where elements of the design have not been completed, these should be clearly set out with an undertaking that when complete, these too will be certified and submitted to the Building Control Authority through the BCMS, the Building Control Management System. The Code of Practice provides that each such incomplete aspect or design element should be identified in the submission accompanying the commencement notice, together with an indicative date by which it is expected that the outstanding design element will be completed. That's caught in section 5.1 of the Code of Practice. And again, I'm just going into the detail as to where that specific requirement stands, but it really emphasises the point that it's very, very important for the contractor to understand what information has been given, what design information, and what remains to be completed.